assistant for the 459th. Before we get started, I need to check your sound to make sure we can hear each other. I have someone, you're just named Jim. What can you come off mute and let me know?
Good morning or afternoon.
Hello, good afternoon. My name is Jim Rich, and I'm with the Office of Attorney General.
Can't hear them.
Got it. All right. Mr. Sergi, was that you?
Yeah.
Somebody?
You can't talk.
Okay. Mr. Ramsey, good
Can
afternoon.
you guys hear me?
Yes, I can hear you. Can you hear me?
Yeah, I can't hear them.
Mr. Ramsey.
Is my sound check?
Identifies as part of its regulatory toolkit.
Is there a page in your 330 plus filing that you can point me to where it's all laid out exactly what they did? Because I'm the emergency judge this week and I do the very best I can, but I cannot absorb all of that in a 5-minute presentation. I really need you to spell it out for me. So can you point me to exactly what page I should be looking at, where you lay out what they did and why it shouldn't be allowed, like the exact words?
Give me 1 second, I'll give you the page number. It's going to take me a couple of minutes, Your Honor. And unfortunately, my arm is not working very well.
I know.
So I can't.
I also, let me take a look. I'm going to open something too. So you are not objecting to the statement that consumable hemp products labeled to contain Delta 8 THC are not allowed to be sold in Texas anymore.
Unless they have, again, trace amounts of Delta 8.
No, listen. Consumable hemp products labeled to contain Delta 8 THC.
Well, I would agree with that as long with the proviso that it has the trace amounts are permitted.
Well, if it's labeled to say it contains it, it has to be more than trace, right?
Well, again, I'm not trying to argue with you, but we don't know what that actually means. As long if it says more than trace, then I would agree with you. If it simply says Delta 8, then I don't think I can.
Why would something be for sale labeled Delta 8 THC if it didn't have Delta 8 THC in it?
Well, no, it would have Delta 8 THC. The question is it more than a trace amount or not?
Well, if it's enough to make someone want to buy it, isn't that more than a trace amount?
That's more of a consumable, and people may want a trace amount, Your Honor. I think we're trying to sell, Your Honor, Delta 9. We're not trying to sell Delta 8. That's, I think, the most important part. But Delta 8 becomes part of the process when you're manufacturing, because when you are in the process of putting of extracting it, you're going to wind up extracting small trace amounts of Delta 8, HHC, Delta 10, a lot of the minor cannabinoids, and we need to have clear direction in the manufacturing process what we can actually still utilize as we're manufacturing. And I believe Mr. Fusto is telling me if you look at page 35 through 39 of our petition, you'll see what you're looking for.
So I'm reading your proposed order right now because those are the words you're asking me to adopt.
Yes, Your Honor. Got the order right here. Yeah.
So again, my question to you is, let's say I grant your request and law enforcement goes out to a shop and wants to seize the products that are labeled Delta 8.
Correct.
Are you saying they would not be allowed to do that?
They should not be allowed to do that until they have defined what is a trace amount. And it's basic rulemaking, which is, again, what we've been seeking is basic rulemaking. What is?
Well,
the-
what was the status of products labeled Delta 8 before July?
They were being sold regularly. You could go to almost any retail store and buy Delta 8 if you so desired.
Okay, and those were products intended to contain Delta 8.
Correct.
And so my question is, do you agree with me that today that's not legal?
We would agree that products that have a commercially viable amount of Delta 8, more than a trace, are illegal under the circumstances.
Okay, that's what I was trying to figure out, because I don't know that your proposed order makes that clear, because it's just one sentence with an or in it. And so I'm not, whatever I do, I'm not signing an order that says you can sell Delta 8, market it as Delta 8, purporting to contain whatever, just for the sake of argument, 50% Delta 8, right? We all agree that's not allowed right now.
Correct.
Okay, so the order that you gave me, I don't think makes that clear. So that was kind of where I was trying to push and figure out.
I guess the problem is, Your Honor, that without defining what a trace element is, it's hard to define what you can't sell. And that's the logical incongruity that we're dealing with, and that all of our retail clients are dealing with. We just want instructions. We just want DSHS to tell us, after appropriate rulemaking, when we've all had the opportunity to comment, what is it that we can or can't sell.
Mm-hmm.
We're not asking you to go back and reopen markets. We are simply asking you to define what a trace amount is, or allow require DSHS more precisely to go back to the APA and do a proper rulemaking attempt to define what trace amount is.
Okay. All right. Thank you. Mr. Rich?
Good afternoon, Your Honor.
Good afternoon.
The first thing I want to comment on has to do with the style of the lawsuit. Among the named parties is somebody named Glenn Hargett as Director of Drugs and Medical Devices Division. I understand that the Department of State Health Services does not have a Drugs and Medical Devices Division, and that no person named Glenn Hargett has been employed by that agency, or at least has not been so employed for the last, or no one has been there for the last 20 years. And so that was one of the first things I wanted to call to Your Honor's attention. Next, the defendants deny in their entirety the claims of plaintiffs 89-page petition, plus the exhibits that were served on them yesterday, and the defendants object to all of the relief sought. Plaintiffs seem to be attempting to draw some distinctions between their current allegations and both the recent Sky Marketing Supreme Court holdings and the issues that are now presently pending before the 15th Court of Appeals in the Texas Hemp Business Council matter. Those distinction attempts should be rejected, Your Honor, as illusory. The hemp industry lost in Sky Marketing. The hemp industry lost again in its emergency motion attempting to prevent March 2026 code provisions from taking effect while the Hemp Business Council case is being litigated. This is yet another attempt by the industry to convince the judiciary to meddle in an area in which the legislature has, according to the Supreme Court in Sky Marketing, vested substantial discretion in the State Health Services Commissioner. Defendants urge, and we will continue to urge, the court to recognize both the jurisdictional and precedent obstacles. Now, that said, this is not an urgent matter, as Your Honor acknowledged seemingly in your discussion with Mr. Sergi, that this is not an urgent matter requiring the extraordinary and emergency remedy of a temporary restraining order. And the order that they're proposing and the relief that they're seeking is not directed in what they seem to be asking for with respect to law enforcement. They've named Department of State Health Services as a defendant, and they're complaining about what law enforcement might do. In addition, the court and the parties in connection with issues that are as nuanced and scientifically complicated as these should have the time to fully brief those legal and scientific and alleged harm issues.
Well, you'll get that opportunity at a TI hearing. This is
but
just a
there's-
TRO for 2
and
weeks or something.
I appreciate that, Your Honor, but there's no reason for any kind of order to be entered today. The timing of plaintiff's suit confirms that the absence of urgency. The Commissioner's Controlled Substances decision about which they're complaining or seem to be displeased, that returning some THC substances to the Controlled Substances schedule, that went into effect in 2021. The Texas Supreme Court upheld that scheduling decision in Sky Marketing in May of 2026, May 1st, 4 months ago. Texas Administrative Code provisions relating to the definition of total THC, which is also part of the petition here, took effect in March of 2026. Now we're here in late August, and they request that this court conclude that those events of months and years ago create an emergency and urgency today. That request should be rejected. The defense asks that the TRO application be denied. If Your Honor has any specific concerns that you want me to address about any of the claims, I'm glad to talk about those, but we just don't get there on this request, on the orders presented, and on the relief sought. It does not satisfy the elements that are necessary to prove in connection with the TRO application.
Well, since we're here and the argument was made that the term trace amounts is being used illegally, right? Because it hasn't gone through rulemaking, maybe you could address that.
So, Your Honor, I believe what the plaintiffs are upset about is a post on the DSHS website. And it is not a rule. It's not claimed to be a rule. It's a statement of the current state of the law. And in Sky Marketing, the Texas Supreme Court specifically said that such policy statements are not subject to the APA rulemaking requirements. Page, if you give me one moment. Page 28 of the Sky Marketing decision said it would make little sense for a modification and publication of the schedules themselves to be subject to 41034 procedures, but a mere website published policy statement purporting to summarize or describe such modifications and publication be subject to separate APA procedures. The Supreme Court went on to say that reiterate that not every statement of an administrative agency is a rule for which the APA prescribes procedures for adoption and for judicial review. The Supreme Court specifically addressed the idea that website published announcements or of what the law is, not necessarily a change in rule, but what the agency understands the law to be, is not subject to the APA rulemaking processes.
Is that where the statement is coming from, Mr. Sergi?
No, Your Honor, the Supreme Court itself used the term trace amounts, but it
Right, but
did
you're not asking me to execute a TRO against the Supreme Court. You're
No.
asking me to do it against the agency.
Yes.
So where is the agency statement that you are upset about? Is it a press release on a web page? Is it a
What?
printed guidance to law enforcement? I mean, I don't know. What is it?
Your Honor,
I
if
mean,
you look at
the
Exhibit R,
case that's on appeal in the
Yeah.
15th, I
Yeah.
heard that at the TRO. So,
Yeah.
you know, I didn't hear the full 4-day TI hearing or whatever, but I heard the TRO on that one. So I understand some of the issues, but I do kind of think Mr. Rich might have a point that this is covered by these other two cases. And that's what I'm trying to figure out.
Your Honor, we don't believe it is, because if you look at the DHS Consumable Hemp Program website and frequently asked questions, which was captured on August 10th, 2026, Your Honor, the PDF at page 316 talks about only trace amounts for detention and referral, and the statement about future APA rulemaking is included. Therefore, they've obviously included the idea of future rulemaking. It's disingenuous for them to argue that they're not, because they've already discussed it in their frequently asked questions, Your Honor. And, you know, if DHS says that the trace criterion isn't a rule, then that doesn't end the case. It raises an alternative question. What is the statutory authority for DSHS officials to use as an independent operative detention and referral criteria? And here, Your Honor, they've said, we're going back to make rules. That's all we're asking them to do, is go back and make the rules.
Is DSHS themselves out there enforcing a trace amount standard? Or is it just law enforcement around the state? Do you have some specific examples
I
for me?
do know that
where they-
we've had
I
a.
was still asking a question.
Okay.
Do you have some specific examples for me where the agency is doing that?
Your Honor, I believe we've had DSHS, a sanitarium, went to one of our clients and asked them about trace amounts. I don't think they detained any of those amounts, but I know that that issue did come up, and I believe it was with Toro. They are not a client in this particular case, although they have asked to talk to me about intervening, Your Honor. But the fact is that it's on the controlled substances schedule that law enforcement now looks to. So it's hard to argue that it's not DSHS doing it, because DSHS is the one that put it on the controlled substances register, Your Honor.
It seems to me that if they had not included a sentence saying trace amounts are allowed, that law enforcement would actually be seizing products with any amount of Delta 8 under the schedule. And that, I don't think you could argue is an improper rulemaking after the Supreme Court's opinion. Am I wrong about that?
Your Honor, the problem is that they don't explain to us what trace amounts, and we don't want to be selling Delta 8. That's not the issue here. The issue is that Delta 8 does show up, and we have to be able to make sure that as we manufacture, we are able to comply with the rules related to Delta 8 and related to what a trace amount is. It's very simple business, Your Honor. Tell us what we can do and tell us what we can't.
Right. And so it seems to me the solution is not, well, it seems to me that what you're actually asking me to do is tell DSHS to remove the language about trace amounts from its guidance to law enforcement until they finish the rulemaking. Is that right?
To an extent, Your Honor, we're asking that it be removed until, and not enforced until they finish their rulemaking.
Which means no product containing any amount of Delta 8 would be legal to sell in the interim.
Well, Your Honor, we'd ask that during rulemaking that products that have minimal amounts of of Delta 8 would be able to be sold, because that's what the Supreme Court already has recognized. We just need to define what it is, and that can be done fairly quickly.
I don't think I can do that. I mean, I don't think a district court judge is allowed to do that. That sounds like I'm rulemaking. I mean, that's my problem. I mean, I don't.
Your Honor, we've got to be able to understand what it is we can and can't sell. And so that's why we have rulemaking, and that's why we have an APA, Your Honor, and that's why we're asking you to enforce the APA. We're not asking you to make the rules. We're asking you to require dishes to enforce the rules and to actually go through the APA and make sure that they have complied with the APA. In other words, we're not asking you to set rules. We're simply asking you to have them make the rules that they should have done in the first place instead of taking shortcuts.
Okay. Anything else, Mr. Rich?
No, Your Honor.
No. I really wish you guys felt more like talking. Well, I don't know. I mean, I thought I was going to come out here and get more arguments that would help me answer these questions, because the way I see it, if I grant the motion, then the guidance to law enforcement is any Delta 8 at all is seizable, detainable, etc. Right?
Your Honor,
Not what you're saying, Mr. Sergi, where it would be even they couldn't enforce it at all. So I don't.
Yeah, Your Honor, if you look at page 93 of our order, I think you'll see exactly what it is. That what we're asking is that dishes be enjoined from treating or applying post-July implementation and enforcement as an independent operative rule or legal requirement separate from the actual text of an applicable statute, the schedule of controlled substance, or a validly adopted administrative rule in determining whether plaintiff's products are subject to detention, referral, licensing consequences, or other regulatory or enforcement action, and detaining plaintiff's products, referring plaintiffs from their products to law enforcement, imposing licensing administrative consequences on plaintiffs, or taking other regulatory or enforcement actions against plaintiffs solely because the product does not satisfy the trace amount criteria stated in the DSHS web page. Most of the order says exactly that, and that's all that we're asking you to do, Your Honor.
Mr. Rich, what do you think would happen if I granted the motion, the TRO?
So, well, we would absolutely ask for a temporary injunction hearing.
Well, I know. I mean, I'm saying like factually on the ground, what's the effect?
Well, the DSHS is allowed to and has scheduled as controlled substances anything other than 0.3% Delta 9 THC by dry weight, any cannabinoid. The Supreme Court has approved of that. That was originally put it back into the controlled substances schedule in 2021. DSHS has said, well, and the Supreme Court had said in Sky Marketing that trace amounts of Delta 8 THC might be found in some naturally occurring plants. However, it is not measurable. And so if in fact it is ever measured, it wouldn't be naturally occurring. And so the order that they're seeking, according to Mr. Sergi, it sounds like he didn't like the phrase trace amounts, but he was willing to go along with the idea that they're allowed to sell minimal amounts. And I didn't quite understand the differences between those two characterizations. And so, Your Honor, DSHS needs to be allowed to
make rules.
I'm sorry, Mr. Sergi.
Sorry,
DSHS has not made a rule. The announcement on its website says what it understands to be the state of the law is, period. The Supreme Court has said on sky marketing, that is not a rule that needs to go through the APA rulemaking process. DSHS has engaged in detention of adulterated consumable products for years. Dishes since 1989, the statutes have been on the books allowing dishes to regulate and detain and contaminated and adulterated food products. Consumable hemp products are under Chapter 431 of the Health and Safety Code, food, cosmetics, or drugs, regulated under the same rules as food. And so if adulterated food, if contaminants are found in these consumable hemp products, DSHS is allowed to, and always has been allowed to, detain them. And if the seller thinks that the DSHS has made a wrong decision, they can contest that and can ultimately pursue a court order to get their products back. There is no irreparable harm here, Your Honor, if in fact some product is detained that should not be.
Okay. Well, I actually don't think I can make the decision right here from the bench. I think I need to, well, probably reread Sky Market and think about it a little bit. And so I'm trying to open my calendar. What I would like to do is get 2 dates from you. One, if I grant it for your TI, and one if I don't for your TI, unless you want them on the same day, Mr. Sergi.
I think I'd prefer not, but I will do whatever makes more sense for the court.
Okay, so if I grant it, then it has to be soon. One, which is a problem because of settlement week. So you'd have to agree to extend it into a 3rd week or have it next week, basically.
Happy to do whatever makes the court happiest.
Would you do that if I grant it, Mr. Rich? Would you extend it a 3rd week so you could come back on the week of the 18th?
You're looking at the week of September 18th, Your Honor?
Yes.
I would have to confer with my clients to be sure.
That's a Friday, the 18th. My calendar was set to 7 days instead of weeks. I apologize. So it's the week of the 14th that I would need to set this TI hearing, which would require, I think, everyone agreeing to an extension, or you don't have to agree if you feel like being stubborn and irritating, and I'll just extend it at the 2-week mark if I grant it.
The 14th sounds fantastic.
14th
Okay.
sounds fantastic to me, Your Honor.
All right. And if I don't grant it, when would you like to have your TI hearing?
We would certainly like the opportunity, Your Honor, to have experts designated and an opportunity for a full briefing and perhaps a couple of weeks after that. So maybe we have plaintiffs submit their expert designations, which we do think are going to be required for some of their claims.
Well, so this case still gets a trial at some point. This is just a TI hearing.
Understood, but in order to wrap the court's head around, there's claims related to monopolization, which is going to require some expert input with respect to what in fact the subject market is. And so we do think that's going to take some time. And so I would propose that plaintiff's experts be disclosed maybe no later than the 14th, and then we have defendant's response sometime on perhaps on the week of the 28th, and then get a hearing sometime thereafter on maybe perhaps the week of October 5th.
Your Honor, I'm looking at our expert, Bo Whitney. He is going to be in DC from the 8th to the 11th. I believe he's in Europe shortly after that. I think I can get him there on the 14th. I will call him.
So the 14th is a Monday of a jury week. I realized, I think I was saying the week of the 14th, but I think both of you took it as the 14th. The other issue is Mr. Sergi filed a motion asking for this case to be designated under Rule 10.2, which means it would only go to one judge. It does act, I'm the emergency judge this week, but it also happens to be filed in the 459th. So that would mean either I have to keep it or I have to convince one of my colleagues to let me transfer it to her court. If she has more free time than I do, basically is what that would come down to. Or yeah, basically that's all it would be. It would be like a who has time to handle it kind of situation. So the week of the 14th, the only day that it could actually be heard, if I'm correct, which I think I am, our dockets are changing a little bit, but I think that would be the 17th in the morning. So I just wanted to make that clear. That would be if I grant the motion, the TRO, which I haven't decided. So that's the day people would need to be available. And we could go all day if we had to. Is that what you are imagining, Mr. Sergi, Mr. Rich?
Since you've already heard a lot of this, I was hoping to kind of cut this down a little bit so that we don't have a 3-day hearing. I was hoping no more than a 1-day hearing.
Okay, that's what I asked you. I said 1 day.
Yeah.
Okay.
And then
All right.
also, Mr. Whitney will be in Europe, although he will be able to testify via Zoom if that could be worked out.
In the 459th, witnesses can testify via Zoom as long as it's not a jury trial. But the Supreme Court has issued some rules about witnesses via Zoom on a jury trial that we don't have to worry about. So that's fine with me, with the caveat that if something goes wrong, I'll strike their testimony if both sides didn't have a full and complete opportunity to examine the witness. So the 17th is going to be the setting.
Okay.
If I grant it. Then Mr. Rich has requested the 5th, October the 5th, which is a non-jury week. But I probably would prefer to do October the 8th. So, which is a Friday, which is the day we handle 10.2 cases in Travis County. So that would be the second date if I don't grant it. Does that work for both sides?
The 8th does not work for me unless I can get somebody else to go up and handle something in Fort Worth on the 8th, but I'll make this a priority.
Okay.
I'm double
Mr.
checking, Your Honor. Yeah, yes, I will be fine with that.
Okay, then I'll pick one of those 2 dates when I make my decision, hopefully later today, but I think I have a little bit more reading I need to do.
Can we have some, I don't know, some briefing deadlines too, Your Honor? Couple of weeks out, perhaps for each date or something to that effect. I know that the 17th is going to be tight.
Yeah, there's no, we don't have enough time to have a briefing deadline. So I would say, obviously, if you send me something on the 16th or the 17th, I'm not going to have read it before the hearing. So the sooner you can get it to me, the better I'll have an opportunity to take a real look at it and really absorb it before the hearing. But I don't really feel like setting a bunch of deadlines on anything that close. Even October 8th is very close for deadlines. Why don't you try to work out a schedule if you need it for October 8th without me and see what you can do.
Understood, Your Honor.
Okay. All right. Well, I'm going to go and work on this and I'll try to make a decision today if I can.
Thank you, Your Honor.
Thank you, Your
Thank
Honor.
you all very much.
And
Thank you
Your Honor,
everyone for
if
showing
there is
up.
any briefing, can I have at least 1 day to respond?
I mean, that would be ideal for sure. I want to make a suggestion, Mr. Rich, to your office, because what was told to me was that Mr. Sergi had been attempting to call the Office of the Attorney General and figure out who to tell about this and couldn't get a satisfactory answer. My office tried to call people at the Office of the Attorney General, and we were unable to get any help at all to get someone here, someone up to date, someone to accept any responsibility. We also tried and emailed the DSHS general counsel at the email address on her website, and it was a bad email address. So While the state is a big entity, it ought to run better than that. There ought to be a way for a judge or a party to get a hold of someone who, even if they are not going to be the lawyer, they will get it to the right person and give a satisfactory answer on the phone. I don't know your
I will answer
official
for Mr.
title at the Office of the Attorney General, Mr. Rich. I apologize. Maybe I should, but I don't. But I would like your office to work on solving that problem.
Your Honor, my
Mr.
boss, Mr. Ramsey, who I think has some comments
Yeah,
on that.
I'll respond for Jim so he doesn't have to step in anything.
Okay,
I will say we had 4 TROs set on us today, tomorrow, and Monday, and
you're a huge office.
Mr. Sergey was the only one who didn't manage to get in touch with us.
Well, I couldn't either, and I tried. And I called the Assistant Attorney General who handled the hemp products case, and they weren't helpful.
Again, Mr. Sergey has several of our contacts information. He's dealing with Mr. Rich on another case just like this one. I think it could have happened if he wanted it to happen.
And what about me? What are you trying to
Yeah,
say about me?
that I will work on, of course, Your Honor.
Okay, please do. There ought to be at a minimum someone who, when my staff calls, is helpful.
Well, John, from here on out, I will call you if you give me your cell phone number, and I will call you directly.
Well, you have my email.
You could call his office. I think that's fine. But I do think you should be reachable, and I shouldn't be in a situation like I was in yesterday, and neither should the attorneys at Dishes who this isn't their job. They shouldn't be in that situation either. So, all right. Well, everyone's on board now, so that's good.
Yes, Your Honor.
All right. Thank you very much. That concludes your hearing.
Thank you.